So this is a case about the right to manage, which is a statutory right for leaseholders of certain flats to acquire the right to manage their building without their landlord's consent. The issue in this case revolves around the correct procedure to acquire the right. Now, the 2002 Act says that in order to acquire the right to manage, the tenants, via their nominee company, have to serve what's called a claim notice. The 2002 Act also says that the claim notice has to be served on certain persons, and one category of persons is intermediate landlords in the building. In this case, the tenant's nominee company consciously chose not to serve the intermediate landlord in breach of the 2002 Act. The Court of Appeal in a case known as Elim Court has previously decided that a failure to serve an intermediate landlord is not fatal to the validity of the tenant's claim. The issue for the Supreme Court in this appeal is whether that Court of Appeal decision was correctly decided. And that broadly turns on two issues. When Parliament specifies a procedure that must be followed, but doesn't say what should happen if that procedure isn't followed, how should the court work out what Parliament's intention is? Now, there's lots of authority in the public law context as to how the court should undertake that exercise. What the Supreme Court has never been asked to decide is how that approach should be taken in the context of private law rights. The second issue that arises for the Supreme Court in respect of the Elim Court decision is whether the facts of that case apply to this appeal. In this appeal, the tenant's nominee company deliberately chose not to comply with the Act and decided not to serve a claim notice on the landlord. In Elim Court, the tenant's company tried to serve but failed to do so. The question for the Supreme Court is, in circumstances where the failure is deliberate, does the reasoning in Elim Court apply?
So this case is being heard in the Supreme Court on the 8th of February of this year. Previously, it's been heard at the first tier tribunal and upper tribunal level, and people will have noticed that it's bypassed the Court of Appeal. That's because we obtained a leapfrog certificate from the upper tribunal, transferring the appeal straight to the Supreme Court, because the Supreme Court is being asked to consider a Court of Appeal decision called Elim Court, and there isn't a lot of point appealing to the Court of Appeal about a decision of their own, because of course they're bound to follow it. So this case started about 18 months ago with a first tier tribunal trial. The first tier tribunal found that following the Elim Court decision, the failure to serve the intermediate landlord wasn't fatal to the RTM claim process. The upper tribunal upheld that on appeal, considering it was bound by Elim Court to come to that conclusion, but the upper tribunal accepted that there is scope for questioning the correctness of Elim Court, and hence transferred the appeal to the Supreme Court, which is now dealing with it, as I say, on the 8th of February.
Well, the first key issue is this will be the first time we get a Supreme Court decision as to how courts and tribunals should ascertain what Parliament intends with respect to procedural non-compliance when it does not expressly say what the consequences are. And in granting permission to appeal to the Supreme Court directly and bypass the Court of Appeal, the upper tribunal noted that that is an issue that is frequently before the lower courts, in particular the County Court and the FTT. So the first point to note is that we will have, hopefully, a judgment which gives out clear and authoritative guidance as to the correct approach. And the second point arises in the context of right to manage in particular. A lot of claims have been stayed off the back of this appeal, and there will be hopefully some certainty as to the effect of a failure to serve an intermediate landlord under the right to manage legislation.
In terms of the implications, of course, much is going to turn on what the Supreme Court ultimately decides. But as Harley's noted, this is the first time the Supreme Court has been given the opportunity to consider what's called the Senegi line of cases, so how you identify Parliament's intention in the particular context of property statutes. So it is very likely that whatever they decide here, whichever way they go on the substantive questions, is likely to have knock-on implications for, say, enfranchisement law, and as well as all other statutory procedures involving services of notices. So you can imagine claims involving notices seeking possession where this will be relevant. You can imagine claims involving statutory rent increase notices under Section 13 of the 88 Act, for example. A whole range of situations which we property lawyers come across all the time, where Parliament says you must do A, B, C if you want to achieve outcome X, but doesn't specify what happens if you do A and B, but don't quite manage to do C. That's going to be the practical implication of this. And broadly, there are two ways this could go. The Supreme Court could say that strict compliance is critical. Any failure, no matter how minor, ends the validity of the process, so it's binary, you complied or you didn't. Or it could say no, there is scope, as the Court of Appeal held in the Elim court case, for a degree of leeway. You look at the practical consequences of failure and you decide what Parliament intended in those consequences. The former approach would lead to, I suspect, more claims being held to be invalid because it'll be a strict bright line rule, but hopefully the flip side of that would be less litigation because there'd be less scope for arguing about whether or not a particular flaw could be saved.
Well, what's next is to actually argue the case and get a judgment, and that's happening, as Justin said, on the 8th of February. In terms of what to look out for, well, I'm afraid I can't say much more other than read the judgment itself. Depending on how the Supreme Court go, as Justin's indicated, it could really mark a significant change in the court's approach to the construction of statutory notices in the private law context. We simply don't have a judgment at this level, considering how the court should consider Parliament's intention where a notice is served that has the ability to affect private law rights but doesn't comply with the notice. If the court takes a much stricter approach, there is potential for this to become a lot more simple in the sense that you either comply or you don't. If the court takes a different approach, who knows?